You sign a lease. You open a bank account. You file a lawsuit if someone wrongs you. You do all of this alone. Nobody needs to approve it. Nobody's signature has to sit next to yours. It's Tuesday-level ordinary. So ordinary, you've never once stopped to think about it. Now imagine you are a woman in England in the year 1250. You are married, and under the law of the land, your legal identity has been absorbed into your husband's. You cannot own property in your own name. You cannot sign a contract. You cannot sue someone who wrongs you. Your husband has to do it for you, because in the eyes of the law, you and he are one person. So, did medieval women have any rights at all? Or is even that question, the one you think you already know the answer to, more complicated than it looks? Here's what most people assume. Medieval women were property. They had no rights, no voice, no legal existence of their own. They were married off as children, treated as chattel, and lived their entire lives under the total control of a father or a husband. And there's a real legal doctrine sitting underneath that belief. It's called coverture, and we just described it. A married woman's legal identity was, in a real and formal sense, absorbed into her husband's. Arranged marriages were common, especially among the nobility. Entire professions were closed to women by law and custom. But here's where it gets more interesting than the version you've been sold. The real picture is not a simple story of total powerlessness. It's contradictory. It changes depending on whether a woman was married or unmarried, rich or poor, urban or rural, English or Flemish or Italian. In some rooms of medieval society, women held real enforceable power. In others, none at all. And the line between those rooms is not where you'd expect it to be. So let's take this apart, layer by layer. Legal status. The law was a maze, not a wall. Here's the detail that gets left out of almost every popular account. Coverture only applied to married women. An unmarried adult woman or a widow held a legal status called femme sole, literally, woman alone. And a femme sole could do almost everything a man could do under the law. She could own property in her own name. She could sign contracts. She could sue and be sued in court, as herself, without a husband standing in for her. A married woman was a femme covert, covered woman, meaning her legal existence was, formally, covered by her husband's. This is where coverture lived. But even within marriage, there were exceptions carved into the law itself. In many English towns, a married woman could register as a femme sole trader, meaning that specifically for the purposes of running her own business, she was treated as a legally independent person, even though she was married. She could sign contracts related to her trade, sue over unpaid debts, and be sued in return, all without her husband's involvement. This wasn't a loophole nobody used. It was a formally recognized legal category, written into borough law in cities across England. So the law wasn't one wall standing between women and legal personhood. It was a maze, with different rooms, different exits, different rules, depending on exactly where a woman stood in it. Property and inheritance, widows had real power. Here's the part that surprises people the most. If a woman's husband died, she did not simply vanish back into her father's household. Under English common law, a widow was entitled to dower, typically 1/3 of her late husband's land, held for her lifetime use. That's not a gift. That's an enforceable legal right. If her husband's heirs tried to deny it, she could take them to court, and she often won. Widows regularly ran their late husband's estates, managed tenant farms, negotiated with merchants, and controlled significant wealth, sometimes for decades. Some of the wealthiest and most powerful landowners in medieval England were widows. Inheritance for daughters varied by region, but it wasn't universally blocked. In parts of France and in some English customary law, daughters could inherit land directly if there were no surviving sons. No male relative required to intervene. In southern France, under certain regional customs, daughters inherited alongside brothers in ways that would have been unthinkable under, say, Salic law in the French royal succession. This wasn't equality as we define it today, but it was not nothing. It was a real functioning system that gave specific women, particularly widows, genuine economic power. Work and commerce. Women ran businesses openly. Picture a busy street in 14th century London. Brewers, bakers, cloth merchants, moneylenders. A significant number of them are women, not secretly, openly, with their names in the guild records. Brewing, in particular, was overwhelmingly a female trade in medieval England. The women who brewed and sold ale, called brewsters, were so common that the profession was, for long stretches, functionally a women's industry. They paid taxes on it. They were fined for bad batches in local court records, which means the courts recognized them as the responsible legal party. Women appear in guild membership roles across Europe, not just as wives helping husbands, but as independent members in trades like silk weaving, embroidery, and brewing. In London's silk trade specifically, women dominated the profession to the point that it was sometimes described as a women's guild in all but name. Medicine is another one. While university-trained physicians were almost exclusively male, women practiced as midwives, herbalists, and healers throughout medieval Europe, and some, like the surgeon Trotula of Salerno in 12th century Italy, were credited with authoring major medical texts that were used and cited for centuries afterward. None of this means medieval women had equal access to every profession. They didn't. But the image of women locked entirely out of economic life is simply false. They ran breweries, they ran shops, they sat on the tax rolls right next to the men. The church, convents as spaces of genuine authority. Here's a subsection that most people never even think to ask about. A convent was, among other things, one of the very few institutions in medieval Europe where a woman could hold formal, recognized authority over other adults, including men in some cases. An abbess governed her convent's finances, property, and personnel with real institutional power. Some abbesses controlled land holdings that rivaled those of minor nobility. They corresponded directly with kings, popes, and bishops. They were, within their domain, executives. And convents were among the only places where a woman could receive a serious education. Literacy, actual reading and writing in Latin, the language of scholarship, was far more common among nuns than among laywomen of any class. Some of the most significant intellectual figures of the medieval period were women who reached that position specifically through the church. The church, in other words, simultaneously restricted women in some ways and created one of the few genuine channels for female authority, literacy, and influence in the entire society. Marriage and consent. Canon law said one thing, enforcement said another. Here's the part with real, uncomfortable tension in it. Canon law, the law of the church, which governed marriage across medieval Christendom, technically required that both parties consent to a marriage. Not the parents, not the Lord, the two people getting married. This was formal doctrine, laid out explicitly in texts like Gratian's Decretum, the 12th century compilation that shaped canon law across Europe. This sounds, on paper, remarkably modern, but formal doctrine and lived reality are two different things. Social and family pressure to accept an arranged match was immense, especially among the nobility, where marriage was a political and economic transaction between families. A young woman who technically had the legal right to refuse consent might have faced consequences that made refusal, in practice, nearly impossible. And yet, there are recorded cases of women in canon law courts successfully challenging marriages on the grounds that consent had been coerced or never given. The right existed, it was sometimes exercised, it was often ignored. All three things are true at once, and that contradiction is the actual history, not the sanitized version where the right didn't exist at all, and not the sanitized version where it was always respected. Let's stop here and let this really land, because what we've just walked through points towards something genuinely disorienting, something that inverts the story you probably grew up with. Some medieval women had more legal and economic autonomy than women did in large parts of the 19th century. The famed sole trader status we talked about, a married woman running her own business, suing and being sued in her own name. That legal category began eroding as English law modernized. By the 19th century, under English common law, a married woman's property, wages, and legal identity were, in many respects, more fully absorbed into her husband's than they had been for a working woman in medieval London. It took the Married Women's Property Acts of 1870 and 1882 to restore to married women in England the right to own their own property and earnings, a right that some medieval women, operating as femme souls, had already exercised centuries earlier. This is not a footnote. It's a structural inversion of the story most people carry around in their heads, the story where history is a smooth upward climb from medieval darkness to enlightened modernity. The 19th century, which we associate with railways and reform and progress, in this specific and very real sense, took something away. It formalized and hardened restrictions on married women's property and legal identity in ways that were for some medieval women less restrictive than what came after. This doesn't mean medieval Europe was some hidden feminist utopia. It wasn't. Most women had none of the specific protections we've described. But the pattern, some women under some conditions held real legal and economic power and lost ground later, not earlier, is the opposite of the story everyone assumes. Progress is not a straight line. It has never been a straight line. And nowhere is that clearer than in the history of women's legal rights across these centuries. Let's anchor this in real names, real texts, real places. Hildegard of Bingen, a 12th century German abbess, corresponded directly with popes and emperors, composed music still performed today, and wrote treatises on medicine and natural philosophy that were read across Europe. She held authority most men of her era never touched. Eleanor of Aquitaine ruled vast territories in her own right, led armies, and outlived 2 kings, one French, one English, while remaining one of the most politically consequential figures of the 12th century. Christine de Pizan, writing in Paris around 1400, supported herself and her children as a professional author after being widowed, one of the first women in Europe known to have earned her living by writing. Her work directly challenged the misogynistic literature of her time, arguing point by point against claims of female inferiority. Alice Chester, a merchant in 15th century Bristol, ran an international trading operation after her husband's death, dealing in wine, wool, and cloth, and was wealthy and prominent enough to fund major civic projects in her city. The legal texture behind these lives shows up in the documents themselves. Henry de Bracton's 13th century legal treatise on English law lays out the doctrines of coverture and feme sole in careful detail, the actual rulebook these women were operating inside or around. London's guild records list women by name as Brewsters, silkwomen, and shopkeepers, paying their own dues. Gratian's Decretum sets out the consent requirement in marriage that canon law courts across Europe cited and sometimes enforced. And English borough court records, the actual case files from towns like London, York, and Norwich, show feme soles suing over unpaid debts and being sued in turn, their names entered into the record exactly as any man's would be. This isn't a reconstructed theory. It's paperwork, contracts, tax rolls, court judgments, private letters. The specificity is the whole point. This is what actually happened, written down by the people who lived it. So why does the myth of total medieval female powerlessness persist? Partly because it's useful. It lets us tell a comforting story about history as a straight line of progress, dark and oppressive past, enlightened present, and an arrow pointing steadily upward in between. It's a satisfying shape for a story. It's just not an accurate one. Rights are not a one-way escalator. They expand under some conditions and contract under others, and those conditions are political, economic, and specific, not the automatic byproduct of time passing. The version of English law that stripped married women of property rights in the 19th century wasn't a step backward through some historical accident. It was a deliberate legal framework, built and maintained by specific people for specific reasons, and it took a specific, hard-fought campaign to undo it. That's the real lesson sitting inside medieval women's legal history. Legal personhood, the basic right to own things, sign things, sue, and be sued as yourself, is not a permanent feature of being human. It is granted, and it can be withdrawn. It has been withdrawn before, in societies that told themselves they were advancing. That should make you look at the present a little differently, not with panic, just with the recognition that whatever rights exist right now exist because specific structures currently support them, not because history has some built-in momentum guaranteeing they'll always be there. So here's the real question, the one that matters more than did medieval women have rights. It's not whether the rights existed. Clearly, in fragments and contradictions, some of them did. The real question is who decided when those rights existed, And what happens the moment those deciders change their minds? Because a femme sole trader in 14th century London had real power, right up until the law that created her category was rewritten by people she had no say over. And a married woman in 1870s England had less power than that medieval Brewster, right up until other people, again not her, decided to give some of it back. The rights were never really about the women holding them. They were about whoever held the pen, and that hasn't changed nearly as much as we'd like to think.